I can't possibly provide you with legal advice in this forum, so it's not offered as such. Think of it as education or attorney advertising, but not legal advice. And with that out of the way, let's talk about the law.
You don't own your own trademarks. That seems like a crazy thing to suggest, and I'm sorry, it's not entirely true. You own your own trademarks. You've come up with them. They're your intellectual property. But I'm going to compare them to some other intellectual property, and I think it'll make some sense as to what I'm getting at here. If you write a book or you take a picture, you have intellectual property there. It's protected by copyrights. If you invent a better mousetrap and you get a patent for that, of course, there's intellectual property there that you own, and you have the rights to do with what you wish. Um, by contrast, trademark is the only intellectual property I can actually think of. Let me know if you come up with something else, but the only intellectual property I can think of that owes its existence to its function. It has to work as a trademark. It has to work as a source indicator, or there is no trademark. There's no IP. There's nothing protectable there. So how do we know? How do we know? What do you mean by a source indicator? Indicator to whom? Well, an indicator to the relevant purchasing public. All right. Who would be looking for your goods or services? Who is going to need to differentiate your goods from the goods of a competitor or related enterprise? Those are the people that matter. And whenever there's an analysis that's taken up in the courts or anywhere, it's going to be done from the perspective of the relevant purchasing public. It's not really going to matter what you think about how cool your trademark is compared to somebody else's. It's not going to be considered from that perspective. It's going to be from the perspective of the relevant purchasing public. So what are the implications of this? I think where it starts is that don't spend any money at all on a mark until you have the highest possible degree of confidence that you get to keep it and that you get to use it and that it functions as a trademark for the public. Don't pay for a vinyl wrap for your delivery truck, a sign over the door, return envelopes, stickers, none of it. It's as a practical matter, avoiding getting the most thorough competitive analysis of the mark that you're proposing. It's just not something you can avoid. It's if you're going to start with an internet search, that's a great place to start, but there's at least 50 different social networks. How there's so many places that a mark could show up, and you really need to do the most thorough job you can before you're going to put a mark into service, whether it's the name of your company or a new trademark for a new product that your company is producing, whatever it might be. So in that sense, it's not just you. You need to consider the relevant purchasing public. They are party to the functionality of your trademark. So I need you to think about it that way. Think about your marks have a job to do, and that job's not being done for you. Really, it's being done for the public. And I think if you take that perspective when you're looking at trademarks and considering what marks you might use, you're not going to tie your shoelaces together and end up in a court battle or having something rejected by the USPTO because it fails to function. So this is all your intellectual property. You have more of it than you think, and I'll be back soon to talk to you again.